All right, good afternoon. Welcome to Division 7 of the Colorado Court of Appeals. We have two cases on the 1:30 docket this afternoon and two cases on the 2:30 docket. I see counsel are ready for the first argument. Have counsel checked in for the second argument scheduled for 1:30?
We have, Your Honor.
Okay. Great, thank you. I'm not going to go over many of the procedures. I assume you've had a chance to look at them or you're otherwise familiar with them. Do you have any questions concerning the procedures? Okay. I do want to say a couple things first. If anyone has a cell phone, and I assume you almost all do, we request that you please turn those off during the arguments, as for some reason unbeknownst to me, they can interfere with, even if they're on and silent, they can interfere with the recording apparatus that we have. And of course, we don't want the arguments to be interrupted by any phone calls or such. Counsel each has 15 minutes. I realize that counsel for the appellant often attempts to reserve time. That'll be up to you, of course, and depending on the questions from the panel. But we are ready to proceed.
May it please the court, my name is John Lebsack, registration 9550. I represent the defendant and the appellant, Colorado Cab Company. In this case, we ask the court to reverse the judgment on two grounds. One, an error in finding a legal duty, and the second, an error in allowing the issue of proximate cause to go to the jury. Each of those issues provide a separate, independent basis for reversal of the judgment. This case arises from an unforeseeable sequence of events. Unforeseeable in the sense that there was no evidence that anything like this had happened before. There was evidence that passengers had gotten into arguments and assaults with cab drivers, but there was no evidence of the second and the third aspects of the criminal sequence that Mr. Glinton, the passenger, committed. And those three separate criminal incidents are an assault on the cab driver, carjacking the cab, carjacking in the sense that the driver was outside, the keys were in it, it was still running. Mr. Glinton got in the car and drove off with it. And the third, and the most serious, was his running down the two pedestrians intentionally. Fortunately, the cab driver was able to jump out of the way. Unfortunately, Mr. Garcia was not able to jump out of the way, and he was injured.
Counsel, I want to clarify a couple of the facts. Yes. First, I understand that there was an assault prior to the carjacking on the victim here, on the plaintiff, correct?
Yes.
All right, so that part's different than that's before the carjacking. The second thing I want to clarify is, in the record, it indicates that somehow this went on for half an hour.
Yes.
Could you explain that?
I have to say, those time estimates don't appear to make any sense. And there were estimates like, oh, it took 20 minutes or it took 30 minutes, and I saw those in the testimony. And that is the testimony. But I think if you look at the video, that is in real time. So the incidents and the amount of time that elapsed is clear on the video. And so let me get into the sequence of events as best that I can, recap it and summarize it for you. So it started when Mr. Youssef, the driver, picked up Mr. Glinton and a friend at 32nd and Zunai. They flagged him down. They drove north on Zunai. This is what the driver testified to. When they got to 44th, the other passenger said, turn right on 44th. So the driver turned right on 44th. They drove east on 44th until they got close to Tejon, and at that point, Mr. Glinton said, stop here. So they stopped there. Then, at that point, an argument starts between Glinton, who's the passenger in the back seat, behind the driver over the fare. The meter apparently read $5.50, and the driver said it's $6.50, and the extra dollar was because there was an extra passenger. So they got into an argument, and the argument started verbally and then escalated to a physical altercation. At that point, the driver gets out of the cab, and the plaintiff, Mr. Garcia, is there. He's standing outside the car. And his testimony was that he had called for a yellow cab some minutes before. He was at his brother's house at 3926 Tejon, which is between 4 and 5 blocks to the south of where this is happening. And he testified that he saw a cab go by, and he thought perhaps it was his cab, but it didn't stop. So he walked the blocks up to 44th. And as he approaches the corner, 44th and Tejon, there's a mini mart there, a 7-Eleven type place where the surveillance camera is. He hears yelling, "Help me, help me, he's trying to kill me, help me, help me." So he goes to where the yelling has come from, and that's the cab. If you look at the video, the cab is just out of sight, but you can see the headlights illuminating the street. So you can see at 2 minutes and 30 seconds into the video, we've got the sight to the, there's 3 videos, we've got the sight in the brief to the video. 2 minutes and 30 seconds, Mr. Garcia walks from the right side to the left and then goes out of sight because the cab is just out of sight of the video. The lights stay on, the headlights, you can see the headlights illuminating the street. And then 4 minutes later, the cab moves. But in that time, between the time at 2 minutes and 30 seconds on the video and 6 minutes and something, that's when the altercation happens because the driver gets out, because he's getting hit. He gets out. Mr. Garcia testifies that he's saying, "Hey, stop it. You know, don't do that in my neighborhood." The driver gets out. Glinton gets out, and he starts punching. Glinton starts punching, and he fights with the driver. He hits Mr. Garcia, and in the middle of that, that's the assault. That ends when Mr. Glinton gets back into the driver's seat. The driver said the door was open and the keys were in it and the engine was running. He gets in it, Glinton does.
Can I interrupt you
Yes.
there? What did Mr. Garcia do when when Clinton started hitting him?
Try to protect himself, I believe, is a fair summary of what the testimony was. He didn't leave the scene. He stayed there. I don't think there's testimony about him punching back or anything. He said that he got hit on the back of his head. And he testified that he doesn't know what it was that hit him on the back of the head. But during this altercation between Glinton and the driver and Mr. Garcia, and Glinton was on one side of it, and then the driver and Mr. Garcia on the other. So it's one guy and Glinton going against the other two. So all he did, I believe, his testimony was that he just stood there and tried to, protect himself. And somewhere in the middle of that, he got hit on the back of the head. But that's not where the serious injuries took place. So for some reason, Glinton sees the car door open, jumps into it, and takes off. And you can see on the video, it's at 6 minutes and 12 seconds. The car, which the headlights are facing east on 44th. The car then appears from that direction, going to the east. Glinton's behind the wheel, and he's driving in a kind of a crazy way. He pulls into a driveway, and he backs up, and it's not a smooth, normal driving. I mean, he's driving like a maniac. And so you can see in the video that there are 2 pedestrians in the area of the street. It's hard to tell exactly where they are, but they are in the area, and that's the driver and Mr. Garcia. The cab leaves. And then at 6 minutes, 45 seconds, the cab comes back, and at 6 minutes, 48 seconds, the cab deliberately, intentionally tries to run down the pedestrians, and the driver jumps out of the way, but unfortunately, Mr. Garcia is there, and he gets hit and knocked up in the air, and I think the cab runs him over.
Counsel, were the
Yes.
pedestrians in the street or on the sidewalk?
Well, this is an area, you can see it on the video, where there's a big, wide parking lot like in front of a 7-Eleven. So it's a mini mart type place.
Okay.
And there's a wide driveway. So it's not a narrow driveway like a house, it's a big, wide driveway onto the street that slopes down. And so it's hard to tell on the video whether the pedestrians are at the end of the driveway, perhaps in the middle of the street.
Okay.
It shows what it shows, but
That's fine.
they're not in the parking lot. They're pretty much, in the driveway. So what happened when Glinton tries to run him down and ram him, he ends up a little bit into the driveway. So he turns to the right to go into the driveway. So, you can see he's steering to hit these people. Okay, so, and Mr. Garcia is thrown by that. So that's a summary of the facts. We think that there were 3 separate episodes of criminal conduct, the last 2 of which were completely unforeseeable from the standpoint of the cab company. The testimony, the evidence was that they had prior incidents with assaults of drivers, but they'd never had a carjacking, no evidence of carjacking anywhere. They'd never had, certainly never had, a cab carjacked and then used as a deadly weapon to strike innocent pedestrians. So this is a case of nonfeasance. And under nonfeasance, you need to have a special relationship. That's the NM versus Trujillo. The issue of nonfeasance is the failure to provide safety precautions. So there was no special relationship between Colorado Cab and the driver. He was not an employee. He was an independent contractor. He leased the car. And there was no special relationship, no common carrier relationship between Colorado Cab and Mr. Garcia, because although he'd called the cab, this was not his cab. And he never tried to get into the cab or alight from the cab. So there's no special relationship, and therefore we believe that under the nonfeasance case law, in particular NM versus Trujillo, the last statement from the Supreme Court on this issue, there was no duty. Foreseeability is key, and it's a common theme, not a common issue in both duty and intervening cause. For some reason, the trial court erred by looking at the entire sequence as one flowing incident rather than correctly looking at the second and third criminal incidents as intervening causes that break the causal chain. So my understanding of the way the court ruled was that once the assault happened, everything after that was foreseeable. And that's just not correct, because the 2 other incidents were unforeseeable intervening criminal acts. So for those reasons, we'd ask the court to reverse the judgment on lack of duty and error in allowing the jury to consider proximate cause. Unless there's questions, I'd like to reserve the rest of my time.
Thank you, counsel.
Thank you. Good afternoon. May it please the court. Chip Schoenberger, registration 41922 for Jose Garcia. I'm going to focus my time on the same 2 issues that Mr. Leipzig discussed, starting with the rescue doctrine arguments that are in my brief. Even if a cab company owes a duty of care to exercise precaution to prevent harm to its employees, its liability, and it breaches that duty, its liability cannot, as a matter of law, extend to a Good Samaritan who tries to assist that driver. That's the ruling that the cab company is asking the court to make today on that issue. And it's based on a fairly narrow line of cases that they describe as the nonfeasance cases, and that's primarily Trujillo and Whitlock. They argue that those opinions control all nonfeasance cases, and they always, without exception, require one of 6 specific types of relationships directly between the defendant and the plaintiff in order for a duty to arise. That is a overstatement of those cases. Neither Whitlock nor Trujillo involved the defendant having a duty or a special relationship with anybody. They also didn't involve a third-party rescuer or Good Samaritan who tried to provide assistance. So in that sense, those cases are not on all fours with this case at all. And in fact, those cases also don't say that when a special relationship exists that gives rise to a duty, that duty cannot operate to the benefit of another person under any circumstance. They don't say that either. In fact, the Supreme Court in Whitlock and I think virtually every other duty of care case, they invoke and reference broader policy principles when they're discussing duty. In Whitlock, the Supreme Court said, duty is an expression of the total sum of considerations of policy that cause the law to say the plaintiff is entitled to protection. Trujillo, similar type language. Taco Bell, similar type language. At times they refer to fairness under contemporary standards.
Counsel,
Yes,
so that analysis, that would apply then to the issue of whether there was a duty to the cab driver, is that correct?
well, the duty to the cab driver arises out of the employee-employer relationship, which the trial court found to exist, and the duty existed. That hasn't been challenged on appeal.
That's a special relationship?
Correct.
Okay. So it seems to me you're arguing that if there, even in the absence of a special relationship between the cab company and your client, there could still be liability under the rescuer doctrine, is that correct?
That's correct.
Okay. Are you defending the court's finding on the special relationship, the common carrier relationship? Because it's not clear in the briefs whether you really are. I mean, you say there was something akin to it. That's your language.
Yes.
Okay, but what's the special relationship between the cab company and your client?
It's interesting that the trial court relied on the Publix cab case, which is a case from the mid-50s, I believe it is. Not so different from this case. In that case, the plaintiff had not retained the cab yet, wasn't the one who called the cab, was attempting to get into the cab in order to retain it, and was injured before he did so. So the court in that case found that there was a common carrier passenger relationship. I would also point out that the passenger status was never challenged at any point prior to the appeal, but the principles underlying why a special relationship gives rise to a duty, I think, are analogous to our situation, because typically the courts discuss that in terms of a relationship that has an element of dependence or trust or reliance. And what the trial court said in this case was, someone should be able to approach a cab. That's how they get their customers. A lot of times, there's testimony in the record, a lot of times they get their customers on the street, they get hailed down. The cab company is in control of their vehicles. They understand the dangers that cab drivers face. They understand the likelihood of success, of assault. And so the trial court found and ruled that a person should be able to approach a cab for purposes of retaining it, to become a passenger without unknowingly being sucked into an assault and then being hurt themselves. So I think those principles are very analogous.
But in this case, counsel, your client approaches the cab and sees that it's occupied.
Correct.
So it's a little different. I mean, he can't, how does he become a passenger of that cab? It's already occupied.
Well,
At that
there's
point, doesn't he know that it's not his cab?
he doesn't know that it's not his cab. He knows that a cab has shown up,
5 blocks from where he was.
correct, and that he was intending to retain it. And there's testimony in the record that a lot of times, and these are also, you know, the more dangerous situations, a cab driver will drop someone off and be hailed right there by someone else. Personally, I've done it. You see a cab, especially when you need one, you see one go by, you hope they're dropping someone off nearby. If you see them dropping off someone nearby, you want to go say, hey, I'm your next fare. That's
Is there
perfectly
any
reasonable.
evidence that that happened in this case, that he hailed the cab? He had called a cab earlier, but
Yes.
did he hail this particular cab? Is there any evidence of that?
He didn't hail this particular cab in the sense that I think Your Honor is using that word, you know, the flagging it down on the street. He called a cab. A cab arrived around the time he would expect his cab to. It was dark. He thought it missed the address. He went down to follow it. He thought it was his. He was approaching it for that purpose. It wasn't until he got close to the cab that he saw that there was a customer in there. Still at that point, perfectly reasonable to say, I saw this cab just pull up. There's a customer. They're probably getting out. I'm gonna use this guy. I think that's a perfectly reasonable inference from the evidence that we have in the record.
The evidence seems to indicate that he heard some kind of argument going on
Yes.
when he approached the cab. Did he make any effort to enter the cab?
He didn't make an effort to enter the cab at that point. At that point, he heard the screaming. He understood that there was an assault going on, and his mindset shifted to, I'm going to help this cab driver who is being assaulted by a passenger. So the time frame between when he thought it was his cab and he wanted to retain it, and when he realized that there was an assault going on, I'm not sure how close he got to the cab at that point. I think he was probably right on it before he could really hear what was happening. But I think the answer to that question is a little bit fuzzy in the record.
Counsel,
Yes.
what did Mr. Garcia do to physically intervene in the altercation between the driver and the passenger?
Well, the main thing that he did, and this is the point that I think is being contested in the briefs a little bit, is whether or not verbally telling Mr. Glinton to stop assaulting this man, just pay the fare, stop hitting him. Speaking is a physical act. I don't think the case law says that you have to reach in, grab the guy, and pull him out. Especially, you know, this isn't a situation where you have an inanimate object that's creating harm. This is a person who has chosen to assault another person. Words are just as effective in getting that person to stop as anything else. And in fact, it worked in this case. He distracted Mr. Glinton enough that Mr. Yusuf was able to get away, largely unharmed. So that is a physical act of intervention to stop the assault.
Counsel, let's go to the issue of proximate cause for just a minute.
Yes.
Okay, so there was evidence of assaults over a several-year period, a number of assaults on cab drivers. But there wasn't any evidence, as I recall, of anything beyond that, you know, beyond those kind of in-cab assaults on cab drivers. I mean, this seems to be kind of a very unique, one-of-a-kind situation where there's an assault in the cab, then there's an assault outside the cab, then there's a stealing of the cab, then there's a turning around and assaulting of people on the street. I mean, how are the latter three of those events foreseeable based merely on the fact that there had been assaults of cab drivers?
A couple of points on that. One, there are incidents in the record, there's a summary exhibit that has 44 prior incidences. Some of those, and I apologize, I don't remember the name or the number of the incident, but at least a few of those involve assaults outside of the cab. So that is covered. And during the trial, when the cab company attempted to limit the scope of that exhibit, the trial judge specifically said, it's relevant, if it's in the cab, if it's out of the cab, or if it involves a person who lost control. That's number one. Number two, the Supreme Court in Taco Bell has already rejected the idea that just because something hasn't happened before means that it's unforeseeable. It's simply a continuation of the reasonable things that might flow from that. And we have to keep in mind in Taco Bell as well, the court said, just because it didn't happen doesn't mean it's not foreseeable. You have to consider everything, the totality of circumstances of these prior events and what might reasonably flow from them. So here you have a cab patron who oftentimes they're intoxicated. That's why people take cabs. This happened on St. Patrick's Day weekend, largest drinking holiday of the year. It involved a violent assault on the cab driver with the intent to cause physical harm. It's already a violent act. Then, excuse me for just 1 second. There are any number of reasons for what might motivate a violent act like that. It could be a hate crime, it could be robbery, it could be just drunken belligerence. But the person is already in a violent state of mind when they're assaulting a cab driver. Is it foreseeable that that person who's trying to cause physical harm would take advantage of the deadliest weapon available to them at the time? Of course it's foreseeable. That's just a natural I understand Your Honor's point. Probably doesn't happen a ton, but it is reasonably foreseeable. That was the same situation in Taco Bell. Nobody had ever been shot. They'd been robbed, but nobody had ever been shot. The court said, doesn't matter. You come in with a gun, you might shoot somebody.
I think the evidence in the Taco Bell case, there have been like 10 armed robberies at that particular restaurant.
Yes.
Okay. I don't think the evidence here relate to a particular cab, okay? So in essence, the duty that was being imposed here was company-wide. I mean, in Taco Bell, it was just that restaurant, okay? It was whether that restaurant in particular they had a duty at that restaurant because of that restaurant's particular history. But obviously, the cab company can't predict which of its cab drivers are going to be assaulted. So it would have to take these precautions that were alleged at trial, should have been taken, for all of its cabs. Is that right?
I think it's a mistake to think of this as a comparison between the one restaurant and Taco Bell and the cab. Cabs, they move around. I mean, it's the nature. So in Taco Bell, the nature of the location of that restaurant, high crime area, that's relevant there. Cab drivers are a target. That's the evidence in the record. It's the driver itself. It's the cab itself. I mean, maybe it's a higher risk when you go into certain neighborhoods, but cab drivers themselves are targets. And
So the answer to my question is yes. It's essentially a duty to take these precautionary measures on every cab because you don't know where
Yes.
the cab's going to go.
Yes, and those precautionary measures include safety training to avoid these situations, how to choose which passengers to pick up, and to avoid assaults under whatever circumstances the cab driver might find themselves in.
All right, but as I recall from the record, the only two precautionary measures you argued were the addition of partition glass and video camera in the cab.
That was the focus of closing arguments. It was not the limitation of the evidence. Our expert testified that the cab should have had lights, it should have had a better functioning emergency button. There should have been more safety training. There were times when, I'm not going to pronounce his name correctly, but our expert testified that during the course of this 3-year period where you're having all these multiple assaults, you should be discussing with your drivers, okay, what happened? How could we prevent this from happening? You should be having a discourse with your employees about these situations. And the testimony at trial was none of that was ever done. And even the cab company's own expert testified that assaults are foreseeable, If you want to avoid them, you should not be picking up anybody who hails you on the street between the age of 16 and 30. Excuse me. And there was one other point I was going to make from his testimony, and it's escaped me at the moment.
And you're out
But-
of time.
And I'm out of time, so I'll rest on the briefs and ask that the court affirm the trial court's judgments. Thank you.
Thank you, counsel.
I'd like to respond on a few points. First, on the rescue doctrine. The case law in Colorado is sparse on that, but I can tell you a few things that are really fundamental to the doctrine. One is that if the defendant doesn't owe a duty to the person who needs to be rescued, then it doesn't owe a duty to the rescuer. So because we didn't owe any duty to the driver, Mr. Youssef, to provide plexiglass barrier or a video camera, we did not owe any duty to someone who would come to the aid through a rescue. We don't.
Counsel,
Yes.
doesn't your argument concerning duty to the driver hinge on your contention that the driver was merely an independent contractor, and the trial court found otherwise?
We do not believe there's a special relationship. The only way that the court found that was employer-employee. We don't think there's any evidence to support that. In fact, it's contrary to the evidence. So if the court found that from the evidence at this trial, there was no evidentiary basis for it, and it's contrary to the evidence. The only evidence on the relationship was he leased the cab and he was an independent contractor. Another aspect of rescue doctrine is that it requires foreseeability of the harm that the rescuer gets involved with. So it must be within the foreseeable risk created in the first place. That risk here was an assault with the, argument with the passenger. It did not extend to the second, third, and fourth criminal acts that occurred later. There was no common carrier relationship between Mr. Garcia and Colorado Cab. Publix is a much different situation. That was a cab who went to a place to pick up a passenger. The intended passenger was trying to get into the cab. The cab parked in a dangerous place right behind a semi, and the semi backed up, pushing the cab into the injured passenger. It's a much different situation. Taco Bell, it's a premises case. It's not a special relationship case. Has no application here. So for those reasons, we would ask the court to reverse the judgment. Thank you.
Thank you, counsel. Thank you for your arguments today. They're very good. Case will stand submitted. We'll issue an opinion in due course. We do have another case scheduled for the docket at 1:30, but we are going to take a recess to reconstitute the court, so the bailiff should announce the recess.
All rise. The court will be in recess.
Good afternoon. We're ready for the second case on the 130 docket. Before we proceed, I want to note the presence today of Senior Judges Marquez and Casebolt, who are sitting on this case. We're honored by their presence, as we are with Judge Marquez on all the other cases. Counsel, you may proceed.
Thank you, Your Honor. Sean Olson, registration number 38017, appearing on behalf of appellants Randy Murr and Devin Sparks. If it may please the court. This case is about one thing. It is about restricting the authority of an administrative agency to that authority which is specifically granted to it by a legislative body. It is about ensuring that when an administrative agency, an agency imbued with the power to restrict a constitutionally protected property right, does in fact impair that right, there is finality in the order that the agency has given. This case is not about police misconduct any longer. This case is not about unduly restricting a police department's ability to discipline an officer. It is simply about applying the rule of law and recognizing that when a decision is final, it is in fact final, and allow the parties involved to move on with their lives knowing that. The need for finality is self-evident. No one whose property interests are impacted by an agency action should have to wonder in the weeks and months and years to come after that decision has been made that impacts that property right, whether that decision will change simply based on a whim, based upon a change of management, based upon a change of politics involved. Those are not the sorts of things our law allows, but it's exactly what happened here. Now, obviously, this is not the first time a question like this has been raised in a court. There are over a dozen courts across the country that have heard cases like this and answered this question: whether an administrative agency can rescind a final order in order that it can issue a second revised order with a greater penalty. It's not a question that's been answered in this state. This will be the first time. But every state, every court of appeal, and every Supreme Court that has looked at this question and considered this question has come down the same way, literally every single time. And they've answered that question in the negative. Each court, whether it's Idaho, California, Florida, Ohio, North Dakota, each one has said that when an administrative agency issues a final order, a final decision, unless that agency has specific legislative authority allowing it to rescind that order, it does not possess the authority to do so.
Mr. Olson, may I ask you a question? The Denver City Charter is the legislation in this particular instance, correct?
Correct, Your Honor.
Is it your argument that the Denver City Charter has to set out every single instance that would govern, for example, hearings, admission of evidence, finality, all of those things that normally come into a general civil case?
Certainly not, Your Honor. No one can certainly conceive of every possible factual circumstance that will arise in the case of an agency presiding over, in this case, obviously, police officers. But the legislation does set out the parameters under which that authority can be issued and used. Now, obviously, in this case, there was authority granted to the manager of safety, and there was authority granted to the chief of police to discipline. And the charter lays out the actions that those entities and those individuals can take. They can discipline those individuals. There's no question about that. And a case cited by the city often, I believe, is Cooper, which said, look, we have this authority, therefore we have broader authority to do anything we want. But that's not what the Cooper court said. The Cooper court, in fact, said, look, there is a range of disciplinary actions that the chief of police and therefore the manager of safety can take. and they laid out some specific examples. The Cooper Court looked at that, and the specific disciplinary action that was taken in that case was a demotion in rank. And that was not specifically delineated. The Cooper Court looked at that and said, look, that is a lesser included authority to the disciplinary authority that the chief of police and the manager of safety already had.
What about the authority of the manager of safety to affirm, modify, or reverse the decision of the police chief, I believe? Doesn't the fact that the charter provides the authority to modify an order by the chief implicitly or imply somehow that he or she has the authority to modify his own decision?
Absolutely not, Your Honor.
Why is that?
The charter lays out the fact that he can approve, disapprove, or modify a disciplinary order. He has a specific set of time in which he can do that, 15 days, according to the charter. And once that 15 days is done, he has to come to his decision, or before that. And at that point in time, he can modify that decision and make up his own decision as to what the discipline in a particular case may be. Once he does that, the language of the charter indicates that he takes that action by a written departmental order, which takes effect immediately.
Isn't the immediate effect different from finality?
The immediate effect is not different from finality, because as soon as that order takes effect, the fact that it takes effect immediately, it then becomes appealable by the aggrieved officers.
Or the other side?
Well, it wouldn't be appealable.
If it was a question of law, for example, that someone, the commission or the manager of safety construed that you felt was totally out of line based on Colorado authority, would the commission be able to appeal that? Or the manager of safety?
Well, the manager of safety would make the initial decision himself. I guess I'm struggling to find a factual circumstance where the manager would make a decision and then appeal his own decision, unless he were looking for guidance on a particular issue. But I don't know that the commission would.
Bad hypothetical.
Yeah, that's okay. But under Colorado law, we know that there is a presumption that when a decision becomes appealable, reviewable by a judicial or quasi-judicial body, that makes the order, the decision by the administrative agency, a final order, because only final orders are appealable to a judicial or quasi-judicial body. I don't know if that answers your question. And when we look at that authority, I think it's important that we look at the authority under the context in which that authority was granted. Now, if the drafters of Denver's charter simply wanted the manager of safety to have plenary authority to discipline and do anything he wanted to do, none of the language in the charter would have been necessary. They simply would have created a department of safety with a manager of safety in charge and left it at that. And that would have granted to the manager all the disciplinary authority he or she needed. But that wasn't the context in which the Denver City Charter was written. The Denver City Charter, along with civil service legislation that is written inside of it, was written to protect civil service employees. It was written so that civil service employees wouldn't be subject to the political whims of those elected. And so it created protections, not for the manager of safety and for the mayor and for the chief of police. It created protections for the individual civil service employees like Denver's police officers.
But saying protection implies that the charter somehow sets forth protective measures, whereas if it's completely silent, as I think all parties agree, it doesn't really say specifically what the manager of safety can do here. Don't you have to imply some authority to take some action when it doesn't say anything?
If I understand your question correctly, I guess I would say the charter does in fact say what the manager can and cannot do. It provides the construct under which the manager can operate. And it is absolutely silent on the manager's ability to rescind a final order.
Correct, it is absolutely silent, I agree, that's my point. Don't you have to imply some authority to take some action besides that expressly delineated? Agency law is pretty clear that you can fill these interstices, I guess they're called, where there's one particular power given and another one given, but this one that you're talking about doesn't fall within either one. So why isn't that agency law apply?
Well, the agency law certainly does apply. It applies to all agencies, and I appreciate you pronouncing that word for me, because I've wondered about that for years.
I don't know if it's right.
But when we look at that, and I've always pronounced it the interstices of a particular enabling statute, it indicates that the authority granted is that which is granted, and that which is granted in between those parameters. What we're talking about here is not finding another form of discipline to fit into one of the slots of discipline that are specifically granted. We're talking about a whole new power outside of that initial power to discipline. And when you look at it through the lens of why the civil service legislation and the legislation directing the Department of Safety and the manager of safety, through that lens of restrictiveness, through that lens that the legislation was meant to protect individual police officers, you then have to read into the spaces a restriction, not a permissiveness, because the legislation itself was meant to be restrictive. But everyone below is reading it to be permissive. And when they read it to be permissive, they look at this and say, well, yeah, he's got the power to decide. Let's give him the opportunity to rescind anytime he wants as well. And that decision simply flies in the face of administrative law. It flies in the face of decisions from every court around the country. There is literally not one court that has granted to an agency the sort of authority that the department wants in this particular case.
Well, counsel, they're not arguing for authority to rescind, as you put it, any time they want. I mean, it's got to be within a reasonable time, and there are several factors the commission set forth in determining whether such a rescission or reconsideration would be appropriate. So it is circumscribed. It's not unlimited.
It's circumscribed as arbitrarily as the commission wanted to circumscribe it at the time. This was a first issue for them. There's absolutely nothing that prohibits them from changing that down the road, from granting the manager more authority later on down the road when something doesn't fit neatly into their ad hoc rationalization of this particular case. So I would argue, Your Honor, that the authority they granted him was much larger, and it continues to be much larger than what they're trying to say it is now. If the court doesn't have any further questions, I'd prefer to reserve the remainder of my time for rebuttal.
Thank you, counsel. You may proceed.
Okay. May it please the court, my name is Richard Stubbs. Registration number is 18009. I'm in the Denver City Attorney's Office, and I'm here representing the City and County of Denver and the Department of Safety. At the table with me is my co-counsel, Robert Wolf, who is also in the City Attorney's Office. Your Honors, the issues in this case are fairly limited. In a 106A4 action, the ultimate issue is always whether the administrative agency has exceeded its jurisdiction or abused its discretion in making their decisions. When this court reviews the CSC's interpretation of its own rules or of the city charter as it relates to the authority of the manager of safety or police discipline, this court should defer to or afford deference to the Civil Service Commission, as that is the agency that administers those topics so long as there is a reasonable basis for the CSC's interpretations. Now, one of the underlying issues in this appeal is whether Denver's manager of safety possesses the inherent authority to rescind a previously issued disciplinary order if the discipline officer has not appealed and the time for the appeal has run. And the answer to that is yes, the manager of safety has inherent authority under those circumstances. And there are a couple of reasons why. One is that the city charter does provide a lot of power to the manager of safety with respect to disciplinary issues. He's involved in almost every step of it, and the hearing officer even has to give deference to the manager of safety's need to administer the department. The other thing is that there is case law, both within Colorado and outside Colorado, that establishes that an administrative agency has inherent authority to reconsider its decisions as long as it's done within a reasonable time. One of the primary cases that addresses that is Trujillo versus General Electric. This is a case out of the 10th Circuit. I'm not going to go into it in any great detail, but it says administrative agencies have an inherent authority to reconsider their own decisions since the power to decide in the first instance carries with it the power to reconsider. This is a case that's been cited by Colorado courts and by circuits outside of the 10th Circuit. A couple of Colorado cases that are important. Denver Local 2-477 versus Metro Wastewater Reclamation District, which is a decision from this court, Your Honors, in 1999. It held that an administrative agency's powers that are not expressly granted or implied if such powers are necessary to carry out the agency's function and if the implied power is exercised in a reasonable manner. Now-
Counsel, let me ask you about that.
Certainly.
Why is this power to reconsider after something's become final necessary?
Certainly, Your Honor, I would explain that. There are many decisions, Your Honor, that are made that have far-reaching implications. And one of the types of decisions that the manager of safety makes that have far-reaching implications are disciplinary decisions. They have impact on the officer that's disciplined, but they also have a huge impact on the public. You know, law enforcement officers are granted extraordinary powers. They can use physical force on an individual, including lethal force. They can deprive somebody of their liberty, including by doing it by an arrest or working with the prosecutors to file criminal charges. So these are extraordinary powers, and it's necessary that the department not only allow the officers to use those powers in doing their job, but to make sure that as they use them, they're not misused or abused, which is what in fact happened in this case, Your Honor. There was a misuse and abuse of those powers. And the evidence in this case that had been presented to the manager of safety prior to the issuance of the original disciplinary orders had not persuaded the manager of safety that there had been that the officers had used excessive force or had been dishonest in their reporting of that. But when the two new witnesses came forward, and it was almost sure luck that they appeared, but they appeared, and once they appeared, the manager of safety, recognizing that it was important to get all the facts in this case, or as many as he possibly could, ordered that the case be reopened so the investigation could continue. And that reopened investigation allowed the manager of safety to have more information, very important information, because
But couldn't that just go on forever? I mean, don't we have to have finality? There could, in a situation like this, in addition to the two witnesses who were later discovered, there could have been multiple other witnesses who later came forward. I mean, when does it end?
Your Honor, I agree with you that finality is important. But the courts have recognized that in the situation where you're talking about a rescission of a discipline, finality has to be balanced against the need to get the decision correct. And the Civil Service Commission considered both of those concerns when it formulated its policy or rule for rescission. It said that a manager of safety has the inherent power to rescind, but it has to be done within a reasonable amount of time in light of the circumstances of the case. Now, Your Honors, you could put a solid line, here's where we're going to cut it off. But if you do that, in some cases, you may be cutting it off too soon. Sometimes that bright line may give too much time.
But the charter itself gives a deadline. It gives 15 days to make a decision. I
It
mean, it's
does.
a hard and fast 15 days. So it seems to me That balancing has been struck at 15 days. Why is it 15 days but? Why is it 15 days and? Why is it 15 days maybe, rather than just 15 days?
The 15 days, Your Honor, is for the manager of safety to actually issue a disciplinary order, as you said. If he doesn't do that, or she doesn't do that in that amount of time, the ability to discipline is lost, okay? But if the manager, it doesn't say that if the manager of safety issues a decision and new witnesses or other evidence comes forward, or there's some other reason that it needs to be reopened, it can't be reopened. That is an issue that was addressed by the commission. The commission, which is, has the authority to interpret the rules of that are in the charter, determined that the charter did not address the issue of reconsideration. But they looked at the charter again and saw with all the power that was granted to the manager of safety, that the manager of safety should have inherent powers to do everything. You know, in the Cook case that was before this court, I think it was in 2003, and you issued a decision, this case found that the manager had inherent authority to demote somebody, even though that wasn't listed in the charter. And it's the same thing in this case. This is a disciplinary issue where the manager, if new evidence comes forward, in this case it was truly new evidence. The people who came forward, Your Honor, were impartial eye and ear witnesses who provided information that had not been heard. As you probably know by reading the record, they said that Mr. D. Herrera, who was the victim in this case, was not resisting at all. And he was...
But counsel, what they said seems to me beside the point on the legal issue. The legal issue is whether the authority exists to even consider it. And we don't look at what they had to say in deciding that legal issue.
No, I understand that, Your Honor. But, well, I understand that you have to set some time frame. But again, the time frame that was set by the commission was a reasonable time frame. And if you look at some of the case law, there are other cases that do exactly that same thing, the cases that are cited. Some of them were cited actually in their brief, and they talk about there's a reasonable amount of time in which for an administrative agency to reconsider. You know, everybody, you know, issues something and sometime later something happens and you find out something new. And you can't do it on a whim. They said you can't have a flimsy excuse. Well, that's pretty low bar, but the fact is, it's got to be some legitimate reason, and it's got to be done within some reasonable amount of time.
But they also have to do it in situations where the person disciplined has not appealed. If the person disciplined appeals that order of the manager of safety, I think the policy itself and the case law would say, that's it. Nothing can change after that. Isn't that right?
I would agree with you on that, Your Honor, that certainly once the the officer appeals the decision to the Civil Service Commission, then jurisdiction transfers to the commission, and the manager of safety cannot take any further action, at least at that point, probably not.
So from now on, why shouldn't anybody discipline just whatever discipline it is? I'm going to appeal because I'm going to protect my right not to have the manager of safety reconsider this and make it worse.
Well, let me say this, Your Honor, that this case was decided originally by the Civil Service Commission in 2003, and that very argument was made at that time that just every cop is now going to appeal every disciplinary decision. It hasn't happened. I don't have any facts, and it's not in the record because the record of this case was built before that. But that has not occurred at all, Your Honor, and it's understandable, too, because it costs some money, and, you know, and if you're going to appeal, you know, might end up going on ahead and doing an appeal, and people just don't want to necessarily go through that. So that just has not transpired at all. People have appealed when they've needed to appeal, and that's the way it's continued to be, Your Honor. Does that answer your question?
Kind of. I'm a little troubled, though, by the notion that that merely by appealing you cut off this right of the manager of safety to reconsider. I'm not troubled by that fact. I'm troubled by the fact that seems somewhat arbitrary to me. He has the authority if there's no appeal taken. He doesn't have the authority if there is an appeal taken, even though the facts could be identical. Witnesses come forward late, whatever. And so the initial decision wasn't right in either instance. Just seems rather arbitrary to me.
Well, the fact is, Your Honor, there are different situations that you're talking about. Obviously, there are different situations. If someone takes the affirmative step to appeal to the Civil Service Commission, the Civil Service Commission then is the agency that's working on the case. They have the jurisdiction. And it's a very basic facet of appellate law that once one level of review takes jurisdiction over a case, then it's lost to anyone else, because you don't want to have two different agencies dealing with an issue like that. In fact, one of the cases cited in the other side's brief dealt with an issue just like that. But when you don't have that situation in which somebody else has assumed jurisdiction, in other words, if they haven't appealed to the Civil Service Commission, it's still open for the manager of safety, if he has a legitimate reason to open it, which he did because of the new witnesses, and he does it within what is deemed a reasonable amount of time, and it was a reasonable amount of time. The manager of safety appealed this, it was 31 days, I believe, after the order was issued, the original disciplinary orders were issued, and it was only 1 day, maybe 2 days after the manager of safety learned that the new witnesses come forward. That is acting promptly, and the Civil Service Commission reasonably decided that that was acting within a reasonable amount of time. And they said that there was a legitimate reason for this. Again, it had to do with the fact that new witnesses came forward who actually had very important information, as it turned out. I was talked to you earlier about the Denver Local 2-477 versus Metro Wastewater Reclamation District case, Your Honor. And it talked about that implied powers exist for an agency if they're necessary to carry out the agency's function and if the power is exercised in a reasonable manner. Okay, that's what this court has said. And in fact, it was done this way. In this particular case, with respect to the agency's function, the charter established that the manager of safety's function is to be all over discipline matters in every respect. With respect to necessary, it was necessary to rescind the original discipline orders here to reopen the investigation so the manager of safety would have all available information to make a decision as to discipline, which on a use of force case is extremely important. In fact, the manager of safety really owes a duty to the public to ensure that the discipline has been done right, just as a manager of safety has a duty to the officer to ensure that no discipline has been imposed unless it was warranted. In this case, we talked about, the previous case talked about exercising discipline in a reasonable manner. Well, again, that was met here because it was done in a reasonable time and there was a legitimate reason for it. I will mention the Cook case because in that case, this board, this court, found that the manager of safety had implied power to demote a Denver police officer. My time is just about up here, Your Honors. I had some other things I was going to discuss, but I will just say that the City and County of Denver asked this court to hold that because the Civil Service Commission reasonably interpreted the charter provisions and correctly applied the law, the commission did not abuse its discretion in determining that the manager of safety had inherent authority under the facts of this case to rescind the original disciplinary orders. Thus, we ask the court to deny the officer's 106A4 action and to affirm the district court decision. Thank you, Your Honors.
Thank you, counsel. Mr. Olson?
Your Honor, you raised a point that I tried to make in the briefing, in that it is absolutely arbitrary to say that an individual who appeals their decision locks the decision in for all time going forward. But if that officer, like the two officers here, accept the discipline and choose not to appeal it, they subject themselves to further review down the road under whatever might be a reasonable time period. Now, Mr. Stubbs is right. There have been other courts that have said that an agency may rescind an order, a final order, in a reasonable amount of time. And the courts that have done that have all told us exactly what a reasonable amount of time is. And if we look at our neighbor to to the east, Supreme Court of Nebraska, stated in Schlossberg, in the absence of a specific statutory grant of authority to rescind a final order, none exists. An order becomes final when no appeal is taken and cannot thereafter be rescinded. It said when no appeal is taken. That's when it becomes final. And the courts in Florida have followed that. And they have said the reasonable amount of time, if that reasonable amount of time exists, ceases to exist when the window for appeal closes. Because at that point in time, the order has to be final, should the individuals accept that order at that point in time without taking an appeal up. Now, Mr. Stubbs mentioned that they simply haven't seen everyone appealing discipline in cases like this. But that's exactly what has to happen. From a lawyer's perspective, it'd be malpractice for anyone in my shoes at this point to not recommend taking an appeal for every single sort of discipline that comes up. Because not recommending that would subject a civil service employee to exactly what happened here. Something coming up down the road where the manager decided, politically or otherwise, that he had to revisit his decision and rescind the initial order of discipline. It's a very real scenario that they've created, and it's absolutely arbitrary. Because they're saying that the final decision is no longer a final decision. It's close to it, but we're not going to call it final. And we're not going to call it final until some arbitrary, reasonable time has passed down the road. And that is not what the law of administrative agencies is meant for. It's not what the charter was meant for. The charter was meant to protect civil service employees during times of good employment. And when they are disciplined, they need to know, be able to know, that they can take the discipline and then be able to move on in their careers, in their jobs, and continue doing the work that they do. And I see my time here is almost up. It's frozen at 5 seconds. I assume that means it's over.
I think
thank
it's
you all
frozen
for
at
your
negative
time.
5 seconds, but that's all right. Yes, your time is up.
Thank you.
Thank you, counsel, for your arguments this afternoon. It'd be very helpful to us. That will conclude our 1:30 docket, and the court will take a brief recess before the 2:30 docket.
All rise. The court will be in recess.
Good afternoon. Welcome to Division 7 of the Colorado Court of Appeals. We have two cases on the 2:30 docket. The first case is Loveland Eisenhower Investments versus the City of Loveland. I see that counsel appear to be ready for that case. Have counsel checked in for the second case on the docket? Okay, good. I assume that you're familiar with our procedures, so I'm not going to go over them, but if you have any questions about them, I'd be happy to answer them. I'd ask anybody in the audience to please turn off your cell phones during the arguments today so that we're not interrupted and so that they don't interfere with our recording apparatuses. Each case, or each side will have 15 minutes, of course. The appellant may attempt to reserve some time for rebuttal. We'll see how that goes, depending on the questioning. One thing I forgot to remind the last group of is that the podium does go up and down. There's a toggle switch, I believe, that allows that to happen, so if you need to raise or lower it, feel free to do so. We are joined today by Senior Judge Marquez. No further questions, we're ready to proceed.
Good afternoon, Your Honors. Josh Marks on behalf of the City of Loveland. As the appellant in this case presents two somewhat related but distinct issues related to governmental immunity. The City of Loveland is here asking that you reverse the trial court's determination that Colorado governmental immunity, or CGIA, didn't immunize two of the plaintiffs' or LEI's claims against the City of Loveland. Both those claims were contract-based, admittedly, but the court found, A, that they were rooted in contract, and then B, found that LEI didn't have a present injury. We submit that both of those findings are in error and need to be reversed, and that we ask ultimately that you remand this case back to the trial court for lack of jurisdiction, because we believe this court can make a de novo review and finding that the claims allege the LEI's claims involve a existing injury and that they could lie in tort, and therefore are barred by the Colorado Governmental Immunity Act. What I'd like to do is, because there's two issues, I'd like to focus my remarks initially on whether the claims could lie in tort, as opposed to whether they present a present injury or not. One reason for that is our briefs, I think, adequately address whether a present injury was alleged or existed or not, and so I'm happy to provide clarification if you direct me to on that point, but initially I want to focus on whether these claims could have arisen in tort. So there's two core principles, though, in looking at that issue that have been embedded by the Colorado Supreme Court and this court. The first principle, when you're looking at whether a claim is or could arise in tort, is that the form of relief that's chosen by the claimant or the plaintiff is not particularly relevant to the analysis. That principle comes from CRS section 2410, 105, and 106, which talk about that the Immunity Act and the immunities within the Act apply to all actions which lie or could lie in tort, and most importantly, regardless of the type of action or the form of relief chosen by the claimant. So in this particular case, the claimant chose to plead contract actions. Now, that's not particularly important to the analysis. What is important is that the court should be more concerned about what could have been argued, not necessarily what was alleged. And I believe Judge Jones alluded to this in your Foster decision from 4 years ago, relying upon the Robinson case. And you said exactly that. The analysis really focused on what a plaintiff could argue. And so it requires a little different focus than a typical case where someone presents a set of claims and the court looks at whether the evidence justifies those claims. This is different in that you look beyond that, you pierce the pleadings, and you try to find what the essence of the controversy is about. And this leads me to the second principle. The second principle is that sometimes some actions can lend themselves to the fact that it will either lie in tort or lie in contract. Other types of actions, these two kinds of actions can coexist with one another. And the Supreme Court pointed that out in the Robinson case. And in pointing that out in the Robinson case, the Supreme Court talked about this very scenario where, for example, in the economic loss situation or where you have an economic injury, many times a party will allege a tort related to improper inducement, fraudulent inducement, or negligent misrepresentation that got the parties into a contractual relationship so that the parties, so that the wronged party can allege both a breach of contract action and a tort-based fraudulent inducement type claim. And in those situations, you have a claim that could lie in both contract and in tort. And in those circumstances, governmental immunity applies, because if the claim could be susceptible to either and both coexist, then the claim ultimately could be argued in tort, and therefore the basic immunities that exist under the Colorado Governmental Immunity Act apply. And that was precisely the case in your Foster decision, Judge Jones, where the plaintiff brought a bailment claim. This was the case with the horse semen that was being maintained by the CSU, one of the CSU departments, and it was provided to CSU to hang on to store, and apparently the lab went up in flames and got destroyed, and the plaintiff, seeking loss from the inability to use the semen, and later on couldn't do so, and as a result, she pled it as a breach of an oral agreement claim. But this court, looking at that, said, well, a bailment claim could also arise in tort. And because it could also arise in tort, it's barred by the CGIA, even though the plaintiff basically stressed that she was not trying to argue a tort claim. Applying those principles now to this action, the facts alleged here, both in the complaint and at the summary judgment level, because what we did was we briefed the governmental immunity issues at the summary judgment stage. So there was a fuller record than, there wasn't just the complaint, there was a fuller record. The allegations and the facts in the record lend themselves to a tort, a fraudulent inducement or negligent inducement tort claim arising out of these two parties. And here's why. It's because the record below shows that LEI and the city were involved in a number of pre-contract meetings. They were planning meetings over LEI's proposed project to the city. And it was during those meetings that LEI claims that it provided the city with its intent to contribute in the future certain water rights that it needed to contribute in order for the city to provide it with water service down the line. LEI said that it provided this information to the city. The city knew about this information. LEI's complaint even goes so far to say that the city approved that and told them it would be okay. And then while this was going on, the city, another part of the city, was involved in a water court case involving very similar water rights, not those precise water rights, but very similar rights. And in that water court case, it resulted in a settlement which the city agreed it would restrict future conversions of the kind of rights that LEI had in its portfolio and the kind of rights that LEI had expressed it was going to contribute to the city, resulting in the scenario in which the city would not accept those water rights. And so LEI, the facts in below indicate that LEI wasn't told of any of this. And they were allowed, and they used the word induced into coming to an annexation agreement and executing the annexation agreement. And that's the same basis for the contract claim asserted by LEI. They claim that the city has breached the annexation agreement because the city won't now accept the water rights that it had. So,
What is the order in which those events occurred?
Sure.
The court decision and the annexation agreement, which happened first?
the court decision, the water court settlement, which
Settlement,
occurred,
okay.
yeah, and was later converted into decrees, but the water court settlement occurred before the annexation agreement was
So the
executed.
city entered into this annexation agreement knowing that it couldn't agree to the terms of the annexation agreement?
No, we're talking two different things. One is there's, the city entered into the annexation agreement and said, you can come into our city and we like your project. But then there's this water component that eventually the developer is going to have to contribute water to the city in exchange for getting the city's water service. And under the allegations that are in the record, the city knew that they weren't going to be able to accept LEI's water rights or the additional water rights that LEI wanted to contribute to the city at the time the annexation agreement was executed. The annexation agreement, however, doesn't address the acceptance of water rights. Okay? The breach of contract claims are based on more indirect theories of liability which address the water rights.
So, counsel, you're saying the annexation agreement does not require LEI to contribute water rights?
No, the annexation agreement doesn't address the contribution of the specific water
Okay,
rights
so it
that
does
LEI has.
address it generally, it just doesn't mention these particular water rights.
It basically says that at the right time, the city will provide water service to LEI based on the same conditions that it provides water to everybody else. That's really what it says.
And those conditions, as I understand it, at that time under the code, would have allowed the city to accept something like the Chubbuck inches.
Well, the city code listed Chubbuck inches as, in two ways. It listed the Chubbuck inches as, it gave a conversion for if they contributed Chubbuck inches, what it would amount to for a credit. But the city code also said at the same time that if you're going to contribute Chubbuck inches, it would be subject to this Utilities Commission's approval and discretion to accept those in the best interest of the city. So it said, it wasn't an automatic provision that said you're absolutely entitled to contribute Chubbuck inches and we'll accept them. But there was a city code provision that addressed this at the time, yes. Did I answer your question about the timing of this?
Well, what I was leading up to, and I think my colleagues here are leading up to, is it seems inequitable if what your opposing counsel states that they entered into an agreement knowing that they couldn't accept it because of the court settlement, which they failed to disclose. I mean, that's a whole different issue, but it seems like the city's getting away with something.
Well, that's, the question of whether this lies in tort kind of begs the question
Right,
of, is that,
I
is that,
understand,
is
I
is that
understand that,
fair?
but it seems to lead to an inequitable result if what your opposing counsel says is true.
Correct. And again, we're kind of, at this point, at the summary judgment level, the city didn't dispute some of those facts. There is a factual dispute as to whether the city, whether LEI told the city that it was intending to contribute these water rights. And in which case, it wouldn't be inequitable for if nobody had asked the city to, to okay or pre-approve, those kinds of water rights. So it wouldn't be inequitable at all because the developer is basically proceeding at their own risk, and if they didn't ask the right questions and didn't protect themselves in the water court and investigate what was happening in the water court, there's really nothing nefarious about any of this. But the state of the record that's before you was on summary judgment, and we didn't dispute the fact that that LEI had evidence that they had contributed or that they were going to contribute this water right to the city.
Thank you.
Thank you, counsel. Your time is up.
Okay.
May it please the court, my name is Catherine Hopping, and I represent Loveland Eisenhower Investments, LLC. And just to address some of the factual questions that this court was asking of Mr. Marks, the city of Loveland was in fact negotiating the annexation agreement with my client, LEI, simultaneously at the same time was negotiating a settlement agreement with the Greeley, Loveland and Irrigation Company. The Greeley, Loveland and Irrigation Company administers Chubbuck inches that owners of certain lands located in the city of Loveland have as part of their property. And what had been happening is that up until the time that LEI, that this issue sort of arose, every owner of Chubbuck inches had been allowed to submit those inches to the city of Loveland, and the city of Loveland had accepted all of the Chubbuck inches that had ever been presented to them and convert them from irrigation use to municipal use in water court. And as part of what the agreement between GLIC, GLIC as we've been calling them, and the city of Loveland was that the city of Loveland was supposed to return flows back to GLIC, but had been refusing to do so. So GLIC got upset and began a water court case demanding that they return the return flows back to GLIC. They entered into a settlement agreement regarding that in January of 2010, in which the city of Loveland agreed that it could keep the return flows on the Chubbuck inches that it already had, but it would no longer convert Chubbuck inches in municipal water court. It didn't notify anybody of that, and 6 months later, it entered into the annexation agreement in, I think, July of 2010. Now, the annexation agreement with my client, LEI, was required as part of an approval of their master plan for development. So in order to get their master plan approved, LEI was required to annex certain properties into the city of Loveland, and it entered into that agreement 6 months afterwards. But it did not know that the Chubbuck inches that it owned, it could no longer convert to municipal use. And I'll begin now where Mr. Marks began concerning the trial court's proper determination that this is a breach of contract case. It is not a claim that could lie in tort. LEI holds a valid contract. It's the annexation agreement, and the terms of that contract speak for themselves and specifically obligate the city to uphold LEI's vested rights in the 2010 code. This obligation doesn't exist anywhere else in the law. This vested right only exists in the annexation agreement. And under that agreement, LEI was vested in that 2010 code, and that 2010 code specifically in multiple places delineated that cubic inches are an acceptable form of water credits that can be submitted to the city of Loveland in exchange for municipal water credits that then the development can use as part of its development. Yes, sir.
I'm sorry to interrupt you. I
No, it's
think you've
fine.
answered my question, but I think what you're saying is the annexation agreement incorporated a code which
did.
mentioned the cubic inches, and so through that sort of interrelationship, therefore the annexation agreement required the city to accept cubic inches.
Yes, and I believe that's true. I believe that it was because we were vested in the 2010 code. The 2010 code, and there's two issues that relate to that. First of all, the 2010 code specifically contemplated cubic inches. It gave you a conversion rate for them, and it said that they were acceptable form of water rights. Not only was that true in the 2010 code, but factually speaking, under that same 2010 code, every other applicant owning cubic inches that presented them to the city of Loveland was allowed to convert their cubic inches for municipal credits. We were the first ones that had never been allowed to do that, and that's important too because the other provision that's in the annexation agreement that that is a breach of contract in this case is the fact that under the annexation agreement, the city has the obligation to provide customary municipal services under the 2010 code in a uniform and non-discriminatory manner with other similarly situated applicants. This 2010 code, which specifically identified the cubic inches, so they were contractually, the city of Loveland contractually obligated themselves to treat LEI in a customary and uniform way with other applicants under that 2010 code who had each been allowed to convert their cubic inches.
Counsel, are you saying then that the city entered into mutually exclusive or contradictory contractual obligations, one with LIC and one with LEI?
Absolutely,
All right.
yes.
But given that, I mean, it seems to me the allegations are that the failure to disclose which is in your complaint, that the city wouldn't or couldn't accept these cubic inches was a breach of the contract.
The failure to accept the cubic inches and provide municipal credits is a breach of the contract.
Well, but the complaint and the summary judgment materials allege that there was a failure to disclose this prior agreement which precluded the city from complying with the contract, with the annexation agreement.
It does, Your Honor. We do make allegations, and I do believe, I mean, the city has different arms that it operates under. And in depositions, what the city's excuse was, well, we have one arm that's negotiating, the settlement agreement with GLIC, and we had one arm that was negotiating with you, but they're all the city of Loveland. But really, those allegations, Your Honor, go to our good faith and fair dealing claim. We had a breach of contract claim and a good faith and fair dealing claim.
But good faith and fair dealing deals with the obligations of the contract and performing those after the contract has been entered into.
Correct.
Now, it seems to me there are allegations both in your complaint and in summary judgment proceedings that the city acted wrongfully in failing to disclose the existence of the prior agreement that would preclude its compliance with the annexation agreement.
Yes, but Your Honor, you have to look at what the source of the duty is. So, because the case law not only says that, you have to look at what you could have pled, and here, the other point that I would make is that we could not have pled a misrepresentation or fraud claim. When this complaint was filed, and we filed breach of contract and breach of good faith and fair dealing, we were limited in what we could actually claim because of the contract that exists. That contract, the annexation agreement, allows us to only seek one particular type of remedy, which is specific performance. There are specific contract remedies, and those are the only remedies that we're allowed to seek. We could not seek tort remedies. We could not seek fraud or misrepresentation remedies because the only available remedies under fraud or misrepresentation is rescission of the agreement, which we couldn't do, and damages, which we could never seek.
But the CGIA would have precluded any tort claims anyway.
The CGIA would have precluded any tort claims anyway. And
But
if
it
you,
sounds like you're saying we couldn't because of legal reasons, but you knew the facts that would have supported the tort claim, and the facts you alleged them.
yeah, we knew the facts, but the fact that the city was negotiating two agreements really just goes to the egregious nature of the breach. It doesn't change the fact that what I have is a legitimate breach of contract claim, because the source of the duties arise nowhere else other than within that contract, to adhere to our vested rights under the 2010 code and to apply that 2010 code to us in a customary and uniform manner with other users. And that's exactly what they've refused to do here. And if I may, there was a mention regarding Robinson, which I think the Colorado case of, the Supreme Court case of Robinson versus the Colorado State Lottery Division is an interesting case. It's not entirely analogous, although they take the position that it is, but it is somewhat informative. There, the plaintiff alleged that the lottery had misrepresented its availability for prizes to induce people to purchase lottery tickets, and the damages claimed in that case was the price of the purchase of the ticket. Right? The court held that this was, in fact, a misrepresentation claim, that they didn't have the prizes, but they didn't tell anybody, and it induced purchasers to buy the ticket, and now the damages are basically, I want to rescind the contract. I want my dollar back, right, for the purchase of the price of the ticket. But think instead, if Robinson had purchased the ticket under the exact same circumstances and won the lottery, say $1 million, and the division refused to give her $1 million prize. Now that would have been a breach of contract. Even though they may have misrepresented the availability of the prize, they had no obligation to give her the $1 million unless she abided by the terms. She filled out the right numbers and she won. Now they have a contractual obligation to give her the $1 million, and that duty arises nowhere else other than the contract. And that is what the court means when they say that the primary difference between an obligation under tort and one under contract is the source of the party's duties. That contractual obligations generally arise from the promises made between the parties, while tort obligations generally arise from the duties imposed by law. The sole source of the duties that LEI claims were breached in this case arise from the annexation agreement. And think about what LEI is requesting in its complaint. In a fraud or misrepresentation claim, the plaintiff is saying, I would not have done this if you hadn't made this misrepresentation, right? They seek to rewind or undo that transaction. But in a breach of contract case, the plaintiff is saying, you promised me X, you didn't deliver X, and I want my X.
But counsel, the statute itself says the form of remedy doesn't control.
It doesn't control, but also in Camas, that was one of the issues that in Camas, Colorado, Inc. versus Board of County Commissioners of Jefferson County took into consideration. Camas involved a construction contract with Jefferson County. The nature of the alleged injury and the relief sought by the contractor was contractual. It was based on a contract addendum regarding specific provisions to pay additional costs resulting from delays caused by action or inaction of the county. And in that case, the court noted that that was specifically a breach of contract case. And as part of that determination, it also noted that Camas was not seeking damages sustained outside its contract with the county. Not only do the source of the duties arise from the contract, but the only relief we're seeking is those required and limited to the contract. And I would also draw a distinction in, there was some mention regarding the bailment case and Foster. And Foster versus Board of Governors of Colorado State University was a bailment case involving the horse semen stems. There was no written contract in that case. But instead, the court hung its hat on the fact that bailment, in order to have a finding that a bailee is liable to the bailor, there has to be a finding of negligence on behalf of the bailor. That's just part and parcel to that claim. And so that could easily have been pled as one or the other. And this is not the case here. In this case, this is a breach of contract case where we have, as part of our complaint, cited to specific provisions of the contract that have absolutely been breached, and they were breached not prior to or leading up to or during negotiations, but years later. The facts of this matter are really interesting in terms of the fact that Loveland not only had negotiated and signed the settlement agreement in January of 2010, didn't tell anybody, it didn't tell my client that it had signed such an agreement, but it continued to operate under that same existing 2010 code for years and years and years. It did not alter the code until approximately 2015. And the other point that I'd like to make, and I think this goes to...
But doesn't that very fact indicate that the city was somehow misleading you?
I don't know that it was trying to necessarily mislead us or mislead anyone, or if it just simply didn't think it needed to amend the code.
But in the summary judgment materials, you expressly say, or somebody expressly said, they knew all this was going on, they knew they couldn't do this, and they enticed us to enter into the agreement anyway.
What it says is that it induced us to enter into the agreement and continue construction. We
Right.
entered into construction, and then we continued to build and develop for years and years later. And so
But again, how is that relevant at all under your theory?
it's not. It's one
So
of the
this was just
defenses
a-
that they're bringing up to say that this is a fraud or misrepresentation claim. And one of the points that I'd also like to raise before, and I have about a minute and a half, and I might bring up injury, I may not, but one of the other issues that I'd like to raise is that the city of Loveland can adhere to the annexation agreement and not violate the settlement agreement. The settlement agreement only requires that they not convert Chubbuck inches in water court. It does not say that they can't accept them and provide us municipal credits. Now, what that does mean is that the city of Loveland would bear the burden of the cost and value of those Chubbuck inches because it would have to accept, under our annexation agreement, the Chubbuck inches. It would have to provide us the requisite municipal credits under the 2010 code, but it could not, as it used to do, go to water court and convert it itself into municipal water. It would have to either use that irrigation water, if it could, somewhere else on public lands, or it would have to just simply accept it, and it would have to bear the burden of the difference of that cost. But it is possible for the city of Loveland to both abide by the settlement agreement and the annexation agreement. And as to injury, we haven't been injured, or we haven't been injured yet until we have to go buy water to replace. And I think the briefing speaks for itself on that matter. And with 5 seconds left, unless there's questions, I'll sit.
Thank you,
Thank you,
counsel.
Your Honor.
Mr. Marks?
I think he's out of time.
Oh, were you out of time?
Yes, he was.
Well, I didn't intend to grant you additional time, so it's my mistake. All right. All right. Well, we do thank counsel for your arguments this afternoon. They will be helpful to us in resolving the case. The case will stand submitted, and we'll issue an opinion in due course. And we will not take a recess after this case. We will simply proceed to the second case on the 2:30 docket. Whenever you're ready, counsel.
May it please the court, Robert Lichty, 14652 on behalf of the Ribblins. The Ribblins took their truck to Midas to get it fixed, check engine light on. A Midas employee stole it and destroyed the truck and all of its contents. The judge below found in favor of Midas because the employee was acting outside of the scope of his employment, and the judge said that, and Midas was not to blame. But this claim is in bailment. It's not a tort claim. I feel like we're picking up where you left off of the last argument. And the appeal concerns really one issue, and that is who is a bailee in a car repair shop context? If Midas is a bailee, who is Midas? Is Midas not the people who work at Midas? All the employees? Aren't they all bailees? Another alternative might be, is Midas only the owner, Mr. Turner, who testified in this case? If so, is he the only bailee? So in order for a customer to have any protection under a bailment theory, does he have to work on the car and not any of the other employees? I submit that if Midas is a bailee, Mr. Rennie, the wrongdoing employee, must also be a bailee because Mr. Rennie got possession of the truck through the arrangement between Midas and the Riblins. And the law imposes the duty that Midas, through its employees, not damage the truck. That was, I think that was all explained in your case, and you sat on the same case, the Foster case, where you explained the nature of a bailment claim. There is no Colorado case stating who are the bailees in this particular situation, that is, in a company that has employees. What did the expert, Mr. Turner, say? He said that Midas pays for an employee's accidental damage to a headlight. He then said that Midas pays for an employee's intentional damage to a headlight. He gets mad and smashes it with a wrench. He said that Midas pays damage to a vehicle while Midas is test driving it. He said that Midas pays for an employee's negligent damage to a vehicle while test driving it, even if it is the employee's fault and not the other driver. The difference between these examples and the Riblins is the cost. But in theory, how the law should apply, there is no difference between those examples and the Riblins example. In all these examples, the employee is a bailee when the employer, who is making money off the employee, gives him access to the bailed item.
Counsel, in each of those circumstances, though, isn't the employee acting within the scope of his employment?
Yes?
Okay. And do you dispute that in this case, the employee in stealing the vehicle was not acting within the scope of his employment?
No,
You don't dispute that?
no. But that's a tort concept.
Okay, it is a tort concept, but bailment includes tort concepts. Even in the breach of contract case, you have to prove negligence. That's the
Yes.
Foster case.
Yes.
Okay, so
Well,
in that sense,
and the reason-
bailment's not a pure contract situation.
But the reason why you had to prove negligence in that case was because of the examples relied upon by Midas. And that is when the damage is caused by an act of God, there was a fire, or by a third party, which is a number of cases, the damage is caused by a third party, then you have to show that the employer, the bailee, was not negligent in some way. Or excuse me, you have to show that the employer, that the bailee was negligent in some way.
So you're saying that in this particular circumstance, negligence is not required?
It's irrelevant.
Okay.
Not only is it not required, it's irrelevant because it goes back to that, to the basic law that in a bailment context, possession by the employee is possession by the employer. And the employer cannot say, I'm not going to follow the law of bailment with you, and neither can he have his employees by actions substantially say the same thing.
So if I
In
can,
other words, the law imposes the duty, you have to return this back in an undamaged condition. Yes, Judge Walker?
sorry to interrupt you. I just want to make sure I understood your answer to Judge Jones. Are you saying therefore that the Christensen burden-shifting framework that our Supreme Court has announced does not apply to this case?
Correct.
Okay.
And the difference is who caused the damage. That's why I said at the top, the appeal concerns one issue. Who is the bailee? Is it only Midas? Well, Midas can't be a bailee because Midas can't do anything. Midas doesn't have any hands and legs. Midas is just it's a name. And I said, well, is it just the owner? Well, if that's the case, then nobody else gets the protection of the law of bailment except people who allowed the owner to work on their car. So therefore, the bailee must include Midas and all of its employees to whom Midas gives access of the vehicle. Now, there's cases that we've cited where the employee came in after hours, did not have access to the vehicle because of his employment relationship. He broke in. In those cases, you do have to show, you have the burden shifting of Christensen, where you have to show the negligence on the part of the employer for not protecting, for allowing that to happen. But in this case, no, because he got possession of the vehicle. He was doing the work of Midas when he went off and did the test drive. The fact that he went beyond that is irrelevant in a bailment context. Because it's not, at that point, we have just a pure contract, well, the contractual liability that is imposed by the law in a bailment context. That's what you have.
All right. Would you agree that there isn't really any Colorado authority for that proposition?
That there isn't?
That there isn't?
Yeah, you're correct. That's correct. This is a case of first impression.
Okay.
And most of the cases that resolve this, you saw our briefs. I mean, 20s, 30s, 52. You know, I think we got one from 76. I mean, the Foster case is the most recent case that we had, but the Foster case doesn't apply because it was not, you know the facts better than I do. It was not an employee who caused that fire. Now, if an employee had tossed the semen straws, well, then we'd have our case. But that wasn't your case, and this has not been resolved before. And the trial judge below said this is a case of first impression. She recognized that. But she fell back onto the Christensen burden shifting. I think that tort law, as opposed to constitutional law, should try to enforce the expectations of its citizens. And I leave you with this thought, because I want to save my time. Ask your wives and your neighbors whether they think a cleaner's or a jeweler or a repair shop should pay for damage to an item that your wife gives to that store. We all know the answer. Of course they do. That's the same rule that should apply in this case. And
But counsel, I mean, that, if we just accept that principle, that just throws the whole acting outside the scope of your authority principle out of tort law. I mean,
Yeah.
because it's fair, I mean, it's your employee who ran down the pedestrian because they were going to work or whatever, they were in the course of their employment. I mean, so aren't we just throwing out that
okay,
limitation in tort
yes.
law too?
No, you're not throwing it out. You're recognizing that the duty imposed here is a contractual-based duty. Remember, a bailment agreement is never put in writing. Well, it can be put in writing in some lease cases that are in the.
So in essence, what you're arguing is the contractual obligation is one of strict liability. You do not return the item undamaged, you are strictly liable.
Isn't that what happens in a bailment context?
Well, not heretofore in Colorado. I
Well-
mean, we've said it's not a strict liability claim.
Yeah, okay. But only if it's caused by somebody, by a third party, or by an act of God. And that's what the majority rule is. That's why we cited the CJS citation. I realize it was a 1988 citation, but because all the cases we have are before 1988, that does still state the majority opinion. And I have a number of cases in there that state that same position. Now, you can say that it's strict liability, but strict liability is a tort concept. I don't think it's strict liability. I think it's contractual liability. That's what I think it is, not strict tort liability. And it's there simply because of the duty imposed in the bailment arrangement. Yes.
Sorry to interrupt you again.
That's-
I think we found a more recent version of the CJS section that you cited in
Right.
the current one. It's in section 71. It says something very similar to what you've quoted in your briefs, but it also says that a bailee is not liable for a loss that results from the theft of the property by its employee, not by a third party, but by its employee, unless the employer was negligent in hiring the employee.
I don't see where those cases are.
Well, it's in the same section that you're relying on.
I know, but I've not seen any of those cases. See,
well,
CGS is only as good as the cases upon which it
Well,
stands, right?
Footnote 3 cites 3 cases, so you might want to go back and read those cases.
And,
But
and
that-
what, is that 2005 or 2017?
2018.
It's 2018 update
2018
to
update.
section 71.
Okay.
Now, granted, those are also very old cases, as you pointed out.
Yeah, they're all old cases. But the cases that we have cited, the case law that we have cited, all states that because of the nature of the bailment duty, not a tort duty, it's a bailment duty. Because of the nature of the duty, if you don't return the object in undamaged condition, in other words, if your employee gets mad and smashes it, is that outside the scope of his employment? Yeah. I mean, Mr. Turner said that his shop would pay for a damaged headlight if his employee smashed it with a wrench. And then he said, well, I'd probably make the employee pay me back. Well, I don't care what goes on between those two parties, but between the bailor and the bailee, yes, the bailee returns it in an undamaged condition.
And just to make sure I'm fair to your position, as I thought your briefs were saying, is that if the employee steals it by coming in after hours, then the employer would not be liable.
Yes,
But if
as
the
long as-
employer gave it to the same employee during hours,
Yes.
and the same theft occurred, then the employer is liable.
Yes.
Okay.
The employer's making money. He's making money in your second example. In the first example,
My second
he's not.
example, the employee also steals it, so the employer is not making money
No,
then either.
No, but he's trying to make money with that employee.
Okay.
See, that's the whole, how did the employee get possession of that item? The employer gave it to him because that's the employer's business. That's the difference, that's the distinction that makes all the difference.
Okay, thank you.
I'll save the rest of my time, thank you.
May it please the court. My name is Theodore Wells, registration number 45909. I, along with Michael Curry, registration number 36681, represent the appellee, DMP Turner Enterprises, DBA Midas of Longmont. I have 2 points to address today. First, that Colorado law imposes a duty of reasonable care on a bailee, not a duty of absolute or strict liability absent an independent contract provision. Second, there's no compelling reason in this case to abandon the established Colorado law. Before I reach those 2 points, I just want to turn back to the appellant's point of the contract versus tort distinction in bailment law. That, in this case, that is academic because this court previously held in the Foster case, I quote, regardless of whether such a claim is pled in contract or tort, the bailee's liability will depend on whether the bailer establishes that the bailee acted negligently. So again, everything turns on the issue of reasonable care and whether the bailer exercised the reasonable care. Second, and very briefly, want to address the appellant's consideration of a witness's testimony, either in the context as the expert or as the owner of DNP Turner. Mr. Turner's testimony, see, it has no bearing on the state of the law or the existence of bailment law. How he conducts his business would just relate to how that business conforms with its legal obligations. So, again, in addition to it being a standard of reasonable care, this court has expressly stated that a bailee is not an insurer. So, and this applies regardless of how a loss occurs, as this court has previously held.
Well, counsel,
Yes, Your Honor.
those cases that deal with both of these principles that you've articulated, my recollection is they all deal with things outside of the bailee's control. None of those cases deal with actions by the employee of the Bailey. And so don't we have to read those cases in that particular context?
Yes, Your Honor. That is correct, that they do not address that issue. And the conduct of the employees goes to a factual issue of how the employer met or did not meet their duty to exercise reasonable care. The control over the employee or lack of control is a factual issue going to the issue of whether there was negligence. Presumably, a bailor could argue and present evidence to say that if a theft occurred because it was committed by an employee versus by a third party, that would be more evidence towards a breach of a standard of care, but it doesn't change the standard of care owed by the employer, by the bailor. And again, this court in the Cole, Tobershoes, and Plummer cases did not articulate a separate standard of care in a case involving theft. Again, as we read the Colorado case law on the subject, the standard is always whether there's reasonable care exercised by the bailee to protect the property. Certainly a bailee and a bailor can contract for a higher standard of care, for the equivalent of a strict liability, but that is not the default position imposed by Colorado bailment law.
Mr. Wells, would you agree that if the employee of the bailee is acting within the scope of the employment, that essentially the bailee, the employer and the employee are the same entity? There's no distinction legally for purposes of showing negligence.
That if the
Basically the same scenario here, but the employee injure or damage the car within the scope of the employee's employment.
If the employee is acting within the course and scope of their employment,
And he acted negligently to damage the car, then the employer would be liable for, right?
yes, Your Honor, I agree that if he acts negligently in his capacity of his duties as an employee within the course and scope,
Okay, I just wanted to make sure you were clear on that.
certainly, but if he steps outside of the course and scope of his employment, he's no longer acting as the agent of the bailee.
What about the situation where the employee is driving the car within the scope of his employment, and another driver negligently hits the car and damages it? The employee is not negligent at all. Is the company, the bailee, liable at all?
Your Honor, if, excuse me, the question, to make sure I understand the question, is has the employer breached has the bailor, in this scenario, breached any standard of care?
Well, that's kind of the question. I guess it's, should the law recognize bailee liability in that circumstance based upon the contractual obligation to keep the property safe?
The law should recognize a duty to keep the property safe, and the duty is recognized as to exercise reasonable care.
And so what's the answer to my hypothetical? Yes or no?
Your answer is, if the employee used reasonable care, if the bailee used reasonable care, then it has satisfied its fallback burden under Colorado bailment law. So, again, because this is an issue applying Colorado bailment law, the Christensen burden shifting applies here in this case, and the district court correctly interpreted and applied that legal standard. Specifically here, the district court recognized that DNP Turner demonstrated that a theft had occurred, so the burden of proving negligence shifted back to the appellants to show that the bailee's negligence and not just the employee's extracurricular criminal activity caused the damages. So that being stated, we should move to the second point of that appellants have identified no compelling reason to abandon the Colorado precedent at issue in this case. Under the doctrine of stare decisis, a court should permit its prior decisions to stand unless they are clearly erroneous or no longer sound because of changing conditions, and more good than harm will come from a change. Here,
Counsel, I don't think they're asking us to abandon precedent. I think what they're arguing is that the precedent doesn't apply, because the precedent doesn't deal with this kind of situation where you've got an employee of the Bailey. I mean, that seems to be their argument. All these other cases don't deal with that circumstance. They deal with the actions of third parties.
Your Honor, that is correct in how they have framed the issue here. However, to reach the way to the standard that the appellants wish for this court to adopt, I believe the court would have to look to circumscribe the reasonable care standard that it has adopted and to create an exception within it where none has existed and none has been recognized. Because this court has previously addressed it in the context of theft, looking to the reasonable care that a Bailey has or has not exercised, and so to come to a rule of where it is an employee that the reasonable care standard no longer applies would circumscribe or abrogate the precedent employing the reasonable care standard.
Mr. Wells, just as a theoretical matter, and from the employer's perspective, the Bailey employer, is there a difference between a third party and an employee who's acting outside the scope of employment?
There certainly can be a factual difference depending on the case. I believe, as far as the law itself goes, there is not necessarily an inherent distinction in that a third party acting outside of the scope of employment is, well, just to be tautological, not acting within the scope of employment, so not acting towards or theoretically close to the interests of the employer. Instead, it is that individual is acting wholly independently.
Well, I guess where I was going is if there's really no theoretical difference between a third party and an employee who's acting outside the scope, then those old cases which talk about third-party theft would seem to apply to the situation where the employee is acting outside the scope.
Certainly, they can have some persuasive relevance to it for that reason.
Thank you.
And furthermore, and now to just addressing one other point that the appellants make of the argument that looking to the cases where a Bailey has attempted to shield itself from liability by pointing to an employer or the employee's conduct, that is a non-issue here because the appellees, DNP Turner, has not argued that the fact that Mr. Rennie acted independently absolves it of its duty to exercise reasonable care. Here, the appellants, as the district court found below, exercised reasonable care and was non-negligent. That was the framework the district court applied. And finally, final point, I just wish to note that the rule the appellants have identified as a majority rule has not been recognized by majority of cases. So what we have is approximately at least nine other jurisdictions have identified the reasonable care standard in the context of a theft. So there is not a strict liability element, regardless of whether the theft is committed by an employee outside the scope of employment or by a third party. So, therefore, because the district court did not err when applying Colorado precedent, we respectfully request that this court affirm its judgment below. If there are no further questions, I will yield the balance of my time.
Thank you, counsel. Mr. Lichty?
Judge Jones, you raise an interesting question. If a third party ran into the car when Midas was test driving it, does Midas pay for it? Yes. That's what Mr. Turner said.
That's what he said, but I think counsel is right. What he says isn't the legal standard. So I take it your answer
But-
to that same question would be yes, they
Yeah,
have to pay for it.
But he is an expert, and he is establishing what the practice is in the industry.
All right, but
To the
experts
degree-
can't testify as to what
okay.
the law is.
Now, what I do want to talk about are the cases that talk about the fact that outside the scope of employment doesn't apply in a case like this. This is the Wink House case. It's from 1987. It's citing another Ohio case, but unpublished case, the state auto case. And that state auto case says, in a case like ours, where you have the employee causing the damage, although the employee's taking of the car was neither authorized by the appellant nor within the scope of his employment, it was appellant who provided the means for the employee to have access to the car by entrusting him with the key to the building and at least ready access to the keys of the car. In essence, the employer, Bailey, delegated and relinquished his total control of the safeguard of the car by giving the employee a building key, which allowed the employee to have access both to the car and the keys thereto. Thus, based on agency principles and responding to superior theory of liability, it is the employer, Bailey, who is ultimately responsible for the property when he entrusts its safekeeping to an employee.
Counsel, just for your information, I found a couple of other Ohio cases, and they left me more confused than ever as to what Ohio's position is on this issue.
Okay. And I think when I was talking about the Illinois case, I came up to the same conclusion. But then the truck leasing case, I think that's perhaps the most clear case. That's a 1952 case cited in our brief, and it says, it is true that unless one has directed a specific tortious act or result or has been negligent, he is normally not responsible for the conduct of others. By contrast, however, by entering into certain relations with other persons, a person may become responsible for harm caused to them by the conduct of his agents or servants not within the scope of the employment. And that's the key here. By entering a bailment relationship, that changes everything in terms of responsibility for your employee's actions. Thank you.
Thank you, counsel. Thank you, counsel, for your arguments today. They'll be helpful to us, and we'll issue an opinion in due course. That concludes the docket for this afternoon. So the court will be in recess, and the bailiff may so announce.